Hello, we are live. Yes, we are live, and we are going to be talking about immigration delays. If you have a question, let me know in the comment. Yes, if you have a question, let me know in the comment. So we're gonna talk about delays, but we need people to just get in the system. Hello, hello, hello. How you feeling? I'm just waiting for a couple people to get here so we can get started. If you want to be live too, let me know in the comments. I can send you a link so you can ask your question live. So, yes, we got people. Okay. Hi, are you from the UK? Okay. Hello, Samuel Nikema. How are you? Who else is here? Let me know in the comment. Before we get started, we're going to talk about delays. If you want to be, oh, from California. Okay, but why are you putting UK? Anyway, so hi. Let me know in the comment. So where are you joining us from this lovely Valentine's Day afternoon, 2 p.m. Eastern time? Oh, it's already 2:06. We're going to do live. We're going to talk about delays, how to deal with it. Okay. And then we're going to take questions. If somebody has questions, they can just really let me know. If you want to ask it live, I can send you a link so you can join us live, or you can just post it in the comments. However you want to do it, let us know. Okay. So let me get right into it. We are going to be talking about delays. How do you deal with it? Well, first thing you try is to expedite the case, right? Expedite request. Okay, let me get into the system and let you know about expedite request. Let me share my screen. Okay, share my screen. Share screen. Okay. I'm sharing my screen with you. Okay. How do you make expedited request? Let me put it a little bigger. I want to focus on one thing only here. So, in general, right, USCIS may expedite adjudication of a benefit request. USCIS consider all expedite requests on case-by-case basis, may require additional documentation to support a request, and has the sole discretion to decide whether to accommodate the request. Okay. So there's a lot of reasons why, right? It says, oh, you can expedite your request based on severe financial loss to a company or a person, provided that the need for urgent action is not the result of the petitioner or applicant's failure to timely file the benefit requested or timely respond to any request for additional evidence. Okay. So they say job loss may be sufficient to establish severe financial loss for a person, depending on the individual's circumstances. Okay. For example, inability to travel for work that will result in a job loss might warrant expedited request. While your work permit's taking longer than ever, or your travel documents taking longer than ever, well, you can try to expedite, okay, based on this reason. if you can prove that you will lose your job, but now they have extended those days for work permit, you might not be able to say you're going to lose your job because they're going to tell you to go with the extension letter. But as far as travel document, well, if you have to travel for work, well, you can show that, okay? The need to obtain employment authorization by itself without evidence or other compelling factor does not warrant expedited treatment, okay? So the one that I really wanted to talk about here is emergencies and urgent humanitarian reason, okay? In the context of an expedited request, humanitarian reasons are those related to human welfare. For example may include but not limited to illness, disability, extreme, you see here, extreme living condition, death in the family, or critical need to travel to obtain medical treatment in a limited amount of time. This one, really, you can, especially when it comes to extreme living conditions, when you have, like, let's say an asylum case pending forever, they haven't called you for the interview, and then you have family member left back home, and you want to expedite your request based on human welfare. You have to be able to prove extreme living conditions. So again, it's a matter of trying, right? But before you try, you have to make sure that you understand how to position yourself in a way that it's really going to give you a chance. Because remember, they look at it case by case basis. So if you read those things, then you can position yourself, okay? They say here an emergency may include an urgent need to expedite employment authorization for healthcare workers. If you're a healthcare worker, okay, during a national emergency such as COVID-19 pandemic, like, yeah, the emergency is still on. They say they're going to lift the emergency in May. But if you work as a healthcare worker, you can try to expedite your request based on based on the fact that you are a healthcare professional. Okay. So additionally, an expedited request may be considered under criteria instance where vulnerable person safety may be compromised to the breach of confidentiality if there is a delay in processing the benefit application. Okay. If you want to travel for vacation, that's not an expedited request. That's not an emergency. So I really wanted to emphasize on this emergency and urgent humanitarian reasons, and severe financial loss to a company or a person. Okay. Non-profit organization, they can, if you work for them, right, they can expedite requests. Expert request whose request is in the furtherance of a cultural or social interest of the United States. But most people fit into this first category and the second one. Okay? So if there is a clear USCIS error, not every circumstance that fit in one of those categories results in expedited request, but it's one of the criteria as well. Then we have the U.S. government interests, such as identified as urgent by federal agencies such as the U.S. Department of Defense, U.S. Department of Labor, National Labor Relations Board, Equal Opportunity Commissions, U.S. Department of Justice, U.S. Department of State, U.S. Department of Homeland Security, and other public safety. So I'm gonna stop right here and go back. So that's how you expedite your request. You look at the criteria and you try to expedite it, right? It doesn't work, try to involve your congressman. It doesn't work, try the ombudsman office. But if the delay is really unreasonable and you try all those things and it doesn't work, that's when you file your lawsuit. Mandamus lawsuit, that's when You go to federal court to get the judge to order USCIS to respond. That's it. That's the result of those lawsuits. UK saying, my case is in the US still since I apply asylum. Now I'm planning to find sponsor from work to get a green card. I have TPS 2. Do I need to leave the country to get new I or not? Please advise. Well, the problem of adjustment of status, I think we have talked about it a lot, right? So in order to adjust status, you have to be lawfully present, okay? So let's say you leave the country. The unlawful presence eligibility requirement still applies. They're still going to look at your previous unlawful presence prior to you applying for asylum. If it was less than 6 months, you're fine. But if it's more than 6 months, you have to find a way to waive it. Employment-based category does not automatically waive unlawful presence. You have to have a way. Like either you have an exception under 245I or your unlawful presence was under less than 6 months. Or you have a way to apply for waiver, 601A, if you have a parent or a spouse which is a lawful permanent resident or a U.S. citizen and still have to get out, right? Once the once the application is approved. So in other words, the UK, you have to check whether you have maintained lawful presence in the United States. For how long? If it's more, if you've been unlawfully present in the US for more than 6 months, unfortunately, with employment basis, you cannot adjust status. Even if you go out, you still have to find a way to waive it. So, Mohammed. Yeah, TPS does not. TPS is just UK. TPS counts from the time being that you have TPS. Prior unlawful presence, TPS does not forgive that. So your real question is to find out how long you have not maintained lawful status before you apply for asylum. How long? If it's more than 6 months, you cannot adjust status, regardless whether you go out or inside. For employment base, you still have to find a waiver or have a 245I. Yeah, Mishad Mohammed. Hi, can you please clarify the relative asylum refugee follow to join adjustment of status based on the new rule? Thank you. You are the one of the best. Well, then what do you mean by the Muhammad? What do you mean by the new rule? The new rule, they were talking about J1 students because they, let me go back to that screen. Let me share my screen, present. If you're referring to this, hold on. Let me share my screen here. USCIS, okay. So news, okay, newsroom. So yeah, first of all, they have updated, they have a new filing location for I-360 and I-485 for self-petitioning abuse spouse. So they have a new location, okay? They're not, it's not Vermont anymore. It's Nebraska now. It's the Nebraska Service Center instead of the Vermont Service Center. So if you're filing for VAWA, you got to know where you're filing, okay? So I'm going to try to answer that question. Okay. USCIS clarify physical presence guidance for asylee and refugee applying for asylum adjustment of status, okay? Let me talk to you about what they mean. So clarifies that asylum and refugee adjustment of status applicant previously admitted J1 or J2, they do not need the 2-year foreign residency requirement if they are adjusting under INA 209. Okay, they don't need the waiver. That's basically what they're trying to do. And then makes minor technical update, including clarifying process for refugees seeking waiver for inadmissibility, removing reference to the obsolete Form I-29 decision, application of status, and adding regulatory citation. So I am not sure what you want me to clarify, but I think what they wanted to talk here is about, some people enter the US with J1, J2, and mostly they are under the 2 years requirement. And if they want to adjust status, they have to file for a waiver, or leave the country, stay there for 2 years, and then adjust status and come back to adjust status or get the visa from outside. But the thing is, if you are adjusting because you won the asylum case, then you don't need that waiver. Exactly that's what they were talking about. Okay, so and then clarification processing step for refugees seeking waivers of inadmissibility. Okay, and then removing references to the obsolete Form I-291 decision on application for status. So basically, that's what it is. I'm not sure if I answer your question. Yeah, I'm not sure if I answer your question, but if you want to take travel document, you should apply for it. You should apply for it. I have withholding of deportation. Individual court coming 6 months cannot have travel document. Oh, Bella, if you are in removal, why? No, don't do it. It's not advisable. If somebody's in removal and what do you mean by when, Mishad? Like, when are they able to apply for adjustment of status? Asylum, you wait for a full year, right? After asylum is granted, you wait for a full year, then you apply for adjustment of status. The requirement is the same. I'm not sure if something has changed. I'm not aware of, but I believe the requirement is still the same. I might double check asylum derivative. Let me double check, but the requirement is still the same. Hold on, let me check. Okay, asylum derivative. Yeah, Mishhad Mohammed, the requirement is still the same, 1 year after the asylum is granted. So UK, do you need a link so you can ask your question live? I'm not sure if I answer your question, because the problem is, even if you go and come with a new I-94, it's the same person, right? So unlawful presence is still the law regarding prior unlawful presence before you apply for the asylum in 2015 still applies. So let me see if I can invite you. So this is the link, okay? Try to get in the link and see if you can ask your question live. We're trying to get people to ask their question live so we can get the full picture. Okay, Mishad Mohammed. That's the link. I put it there. Try to get there. I'll put you on my screen to see if you can ask your question live.